The espionage cases of 1919, Schenck v. United States, Froelich v. United States, Debs v. United States, and Abrams v. United States, represent an important chapter in the history of American civil liberties. Decided in the aftermath of World War I, the espionage cases address the fundamental question, who has the right to criticize the government, especially during times of war? In order to understand the importance of the espionage cases, we need to put them in historical context. In 1914, the assassination of Archduke Franz Ferdinand and his wife Sophia in Sarajevo plunged Europe's imperial powers into 4 years of bloodshed, known as the Great War. Horrified by images of trench warfare, many Americans initially favored a policy of strict neutrality, yet effective British propaganda, German submarine attacks on American merchant ships, and the Zimmermann telegram, a communique which allegedly urged Mexico to invade the United States with German support, generated support for American intervention. On June 2, 1917, President Woodrow Wilson asked Congress for a declaration of war, quote, to make the world safe for democracy. Even before the United States formally joined the fighting, the Wilson administration began to put the U.S. on a wartime footing. War Industries boards managed the economy. The newly formed Committee on Public Information fed ordinary Americans a steady diet of anti-German propaganda. In May 1917, Congress passed a Conscription Act, which allowed the government to draft thousands of men into military service. An accompanying Espionage Act criminalized any attempt to prevent the recruitment of American soldiers. A Sedition Act passed in 1918 threatened that those who might, quote, willfully utter, print, write, or publish any disloyal, profane, scurrilous, or abusive language about the United States could expect hefty fines and prison terms. Public support for the war effort was widespread but far from universal. Many Irish Americans and German Americans felt little sympathy for the British cause. African Americans and Native Americans remained ambivalent about fighting a war, quote, to make the world safe for democracy, when they were denied basic rights at home. Labor unions and pacifists condemned the war as a conflict born of capitalist greed. The American Socialist Party was one of the most vocal critics of the war. In August 1917, party delegates in Philadelphia voted to print 15,000 pamphlets urging nonviolent resistance to the Conscription Act. Comparing draftees to slaves and convicts, the pamphlet implored, quote, if you do not assert and support your rights, you are helping to deny or disparage rights which it is the solemn duty of all citizens and residents of the United States to retain. Secretary General Charles T. Schenck took responsibility for printing and mailing the pamphlets. On August 28th, federal agents raided the Socialist Party's Philadelphia headquarters and arrested Schenck for violating the Espionage Act. In December 1917, a federal district court sentenced Schenck to 6 months in jail. Aided by the National Civil Liberties Bureau, a forerunner of the American Civil Liberties Union, Schenck launched an appeal to the United States Supreme Court. Ironically, World War I ended before the Supreme Court heard Schenck's case. At trial, Schenck's attorneys argued that their client had merely exercised his First Amendment rights by urging nonviolent resistance against what he considered an immoral conflict. Governmental lawyers countered that Schenck's pamphlet, in urging draftees to resist military service, clearly violated the Espionage Act. Behind closed doors, Chief Justice Edward Douglas White and his colleagues selected Associate Justice Oliver Wendell Holmes to deliver the decision of the court. A former Harvard law professor, Holmes was the logical choice for this task. In a previous case, Patterson v. Colorado, heard in 1907, Holmes had argued that journalists should be allowed to publish articles with, quote, no prior restraint, but they were still liable for statements that had the, quote, bad tendency to harm the public good. 12 years later, however, Federal District Court Justice Learned Hand in Massa's Publishing Company versus Patton, heard in 1917, said that there was a difference between speech which agitated for peaceful political change, such as repeal of the Espionage Act, and statements which urged violent resistance to federal law. Although reversed by the Federal Circuit Court, Hand had raised questions about the bad tendency standard, which Holmes planned to address in his Schenck decision. On March 3, 1919, Holmes handed down the unanimous decision of the Supreme Court in Schenck v. United States. He began with the observation that freedom of speech was not absolute, but depended upon timing and circumstances, noting that, quote, the most stringent of protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. Holmes determined that Schenck's actions represented a, quote, clear and present danger to federal recruitment efforts. Schenck would therefore have to serve his 6 months in prison. Holmes promptly used his clear and present danger standard in 2 additional unanimous Supreme Court decisions. In Froward v. United States, Holmes held that a reporter who had criticized Woodrow Wilson's wartime policies in a German-American newspaper could be prosecuted under the Espionage Act. In Debs v. United States, Holmes insisted that public comments made by labor organizer and leading socialist Eugene V. Debs, which praised individuals who had actively resisted the draft, quote, had as their natural tendency and reasonably probable effect to obstruct the recruitment service. The subsequent case of Abrams v. United States, however, would prove a more significant challenge to Holmes's clear and present danger test. In October 1917, Russian Bolsheviks overthrew Russia's provisional government and established the world's first socialist state. In March 1918, the new Russian government made peace with Imperial Germany and Austro-Hungary. Alarmed that socialism might spread across war-torn Europe, President Wilson announced plans in July 1919 to help supply Russian White armies fighting Bolshevik Red forces in the Russian Civil War. In August 1918, 4 Russian-born immigrants living in New York City, Jacob Abrams, Hyman Lachowski, Samuel Lippman, and Molly Steiner, printed 5,000 circulars condemning American intervention in the Russian Civil War. One leaflet dismissed Wilson's decision as, quote, German militarism combined with Allied capitalism to crush the Russian evolution. A second circular, written in Yiddish, implored, workers, our reply to this barbaric intervention has to be a general strike. On August 23rd, Abrams and his colleagues dropped the circulars from a window of their New York apartment building. Arrested under the Sedition Act, a federal circuit court sentenced each defendant to 15 to 20 years in prison. Abrams quickly appealed his decision to the United States Supreme Court. Given the Schenck, Froward, and Debs precedents, many observers expected the High Court to uphold Abrams' conviction. To be certain, Associate Justice John H. Clark handed down a 7-2 majority decision, which stated that the circulars, by calling for a general strike, posed a clear and present danger to America's combat readiness. In one of the greatest reversals in Supreme Court history, however, Justice Oliver Wendell Holmes joined Associate Justice Louis Brandeis in a spirited dissenting opinion. Since the Schenck case, Holmes had become alarmed by the federal government's increasingly harsh suppression of dissidents, even as the war was coming to an end. Correspondence with Learned Hand and Harvard law professors Zachariah Chafee and Ernest Freund also caused Holmes to rethink his views. In particular, Chafee's recent book, Freedom of Speech in War Times, convinced Holmes that freedom of speech had served a vital role in preserving American democracy, and that previous attempts to curtail it, such as the infamous Alien and Sedition Acts of 1798, had inevitably produced more harm than good. Holmes's dissent acknowledged that free speech could be regulated if it posed a threat to public safety. However, quote, nobody can suppose that the surreptitious publishing of a silly leaflet by an unknown man would hurt the American war effort. Schenck, after all, had only sought to end American intervention in the Russian Civil War, not U.S. involvement in World War I. Holmes concluded that in a free society, quote, the ultimate good desired is better reached by free trade in ideas, and that, quote, we should be eternally vigilant against attempts to check the expression of opinions that we loathe and believe to be fraught with death, unless they so imminently threaten the law that an immediate check is required to save the country. Holmes's stirring words did little to help Abrams, but they did help to raise public awareness of the importance of free speech, particularly in times of war. Supreme Court justices throughout the 20th century would further refine the clear and present danger test to one in which, quote, imminent lawless action had to be proven before freedom of speech could be curtailed, a concept which judges and juries still debate today. Although the issue of free speech during wartime continues to be controversial, many of the contours of this debate were shaped in the espionage cases of the First World War.